Good morning, everyone. My name is Faith Eason from Work Health Safety Management. Today, I'm going to talk to you about work health and safety, the work health and safety law in New South Wales. So this training will last about 10 to 15 minutes. At the end of the training, if you can just send me some questions. If you have any questions, that would be really helpful. I'm happy to help you. If you have any comments, that would be very helpful to me as well, because it just means, I'll know what topics to address in future, or otherwise I can just improve on my current presentation. So with this training, I have a template which I'll attach, and that template will be for your benefit to be able to use and see, because it will correlate with the training, and it could help you either in setting up your systems or get just a better understanding in terms of, what the training is about and how it relates to the document. So the key learning outcomes is why WHS, or Work Health and Safety, and not OHS, or Occupational Health and Safety. I'll talk about the harmonization of the law, what that's about. I'll also talk about the key changes that we've experienced in the last 7 years. So what happened in about 2009? A number of industry bodies got together and basically what they were experiencing was, as larger organizations, they had branches in different states and different territories. And what they found, that different states and territories were interpreting the law very differently. So that made it very difficult for them to manage health and safety. So you can imagine if they had maybe one in every state, so maybe they might have 4 or 5 different branches, and each one of them had a different interpretation. So they couldn't, each state had to develop their own form of training and their own manuals, and be able to try and ensure that they forming some sort of making sure that each person or each personnel or each worker is understanding or getting the right training. But with each of them being very different, it made it a lot more complicated. So these industry bodies got together, and that's about 2009, and they began to work on unifying the law. The goal was that by the 1st of January 2012, all the states and territories would be on board, and they would then implement the new work health and safety laws into their business. And the goal was that, they get greater consistency and certainty within the work health and safety business, and I suppose manage their due diligence effectively throughout. So the important thing to emphasize is, yes, we're talking work health and safety law, but the principles are still the same in terms of occupational health and safety. So again, we're talking about plant and machinery, to ensuring that we're maintaining the equipment, to ensure that it's safe to operate and it's not going to harm any of the workers. Implementing safe systems of work, making sure we give workers the correct instruction and the training for them to do their job safely. To implement consultation processes to ensure that we're having those discussions around ensuring the safe work and making those changes where necessary, to ensure that we put in best practice, etc. And then also implementing rehab and injury management processes where workers have been injured, and to make sure that the insurances are covering for their medical treatment, they make up pay, and they're getting the support they need in order to return to their pre-injury duties and to return to work safely. And the big one is, once we have those incidents and injuries, investigate them so that we can put strategies in place to prevent those happening again and injuring the workforce. So what was new for New South Wales? So I'll cover these more broadly, but basically it was, they spoke of employer and employees, employer obligations, consultation processes, OHS reps, entry permits holders, and penalties for breaches. So I'll cover these separately. So first one, employer and employee. So these were the terms used in the last legislation, which is the WHS legislation of 2000 and regulation of 2001. So when the industry body got together, they said, look, we've got corporates and they come under corporate clauses, so directors of companies. They're not employers, they're directors of the companies. Then we also got things like sole traders. We've got deans of universities. So we need to get a term that covers this particular type of personnel who are decision makers and influencers, can influence change within different businesses, institutes, organizations. So this is when they decided to use the word a person conducting a business or an undertaking. So because it's quite long, we tend to call them the PCBU. Then they looked at employee. They said, well, we don't only have employees, we have students doing work experience, we have apprentices, we have contractors, we have volunteers. We need to have a term that covers all of them. So they decided to call them workers. And if you really think about the term workers, all those people are actually working. So workers is the ideal term to use. One of the biggest changes for New South Wales, the most significant change, was that in the previous legislation, all the onus fell on the employer in the work in terms of safety. So in other words, what would happen is that, say in a workplace you had an employee. The employer ensured that they had safe systems of work, they had all processes and systems in place, they did their due diligence. And the employee was non-compliant, and as a result of being non-compliant, they caused a serious and significant workplace incident or injury. And as a result, work cover had to come in that time, which was work cover, as well as maybe there was legal matters as well in it, etc. And as a result, because of the significance of the whole incident or injury, there was breaches and penalties involved. But because this law said that employees must ensure a safe workplace, the onus fell back onto the employer rather than the employee, although the employer did all that was possible to ensure a safe workplace. So in other words, the penalties that the employer had to pay was penalized, and not the employee who was non-compliant. In this new Work Health and Safety Act of 2011, the PCBU is required to do all that is reasonable and practicable to protect the health and safety in the workplace. So what this is saying, so in other words, in this instance, what they're saying is that if the PCBU does all that is reasonable and practicable, in other words, if they do their due diligence and the worker is non-compliant, it is the worker that is going to be punished. It is the worker that's going to be penalized, not the PCBU. So through the process of law, if they deem that the PCBU has done all that is reasonable and practicable, then they will look then at the worker. And if the worker is deemed non-compliant, the worker will be the one that will be punished. So that is very significant for every one of us in the workplace. That's the most significant change. And it's important, you know, as a PCBU, to make this very clear to workers. Make sure they understand that this is what the new law is saying or stating. We then go on to, we had OHS reps. Now we got the HSR. So HSR stands for Health and Safety Representatives. So the role of the HSR has changed a little bit. In the previous role, you know, or any members that were on any staff workers that went on to become committee members had to go for a 4-day training. And in this 4-day training, they had to do the 4-day training in order to be part of the committee. So this doesn't have to happen anymore. Yes, the HSR has been given additional powers over and above the general. And one of those is they can, they got the powers to stop work, and they also got the additional power to issue provisional improvement notices. Having said that, there is a criteria that they have to meet. Part of this new legislation emphasizes is that there must be consultation. So in other words, the HSR can't just go in and say stop work. They have to consult, so with the management team, supervisors, etc. And in that consultation process, they have to come up with how they can manage that issue, that process safely. So say, for instance, say they're in a manufacturing plant and maybe a bit of machinery, equipment breaks down, perhaps the guard breaks off, working parts of the machinery are exposed. So what would happen in the HSR would meet with the supervisors and the managers and discuss how they're going to manage this. So say, for instance, the client, this is an order, there's a timeline, the client needs it, you know, within a day or two, and they need to proceed with this in order to meet the timeline or the time frame. Then maybe when they're looking at the repairs, maintenance can only get there 2 days later. So they might sit down and say, okay, this is what we can do to make it safely, you know, barricade the area, retain the staff on the new process, and get the machines to continue to move until the technicians can get there 2 days later and fix it. So again, it's that collaborative effort between the HSR management team, staff, workers as well, to be able to manage that safe workplace. Also, in terms of the HSR, they say that HSRs can nominate themselves. However, like in larger industry, we also spoke about the training, but in larger industries where you have, you know, like construction or mining, where there's more physical risk, then they said that that's when they recommend that perhaps the HSR could go for training because it's more complex, it's you know, more high risk. So the HSR would then go for specific training. So entry permits are more related to unions, etc., union members entering the premises. So in terms of a small business, this is not relevant. There are changes, but they're not that significant. So again, a big part is the penalties. The maximum penalties have increased by over 300%. So this is quite significant. So in the previous legislation, an individual will, the maximum penalty would be up to 82,500. Today, with the directors and officers, that's 600,000. With the workers, it's 300,000. If you're looking at both of those figures, that means people can actually lose their homes for non-compliance. If you're looking at corporates, the maximum in the previous legislation was 825,000. Today it's 3 million. So again, very, very significant increase. And again, it could mean, a workplace could close down because of that. So one of the most important documents, policies in any business is the work health and safety policy. As I said, I've provided you with the templates. But what a business needs to understand is the work health safety policy is the main policy. It's where they are committing to ensuring a safe workplace. So any other policies, procedures that follow on from this are just are there to just support the main document or the main work health and safety policy, or to demonstrate or support and show how they are going to manage a safe workplace. So I've supplied you with the document. Take a look at it. See, if it's something you want to use. Maybe put a logo put your logo at the top. Sign it, date it. One of the most important things is to be able to, put a copy maybe on your notice board in the lunchroom so all your workers can have a look at it. Some businesses like to have a framed copy in the reception area, so do that. But most importantly, educate your workers around that policy and let them know your commitment to a safe workplace. We also have an update in the work health and safety laws, which is now no longer 2011, 2018. So what happens with work health and safety? There's that continuous improvement. So when a law is set up, there's still that monitoring of any incidents or injuries that come up, and when they're significant, they look at them against the law. And if there's a reason to improve that, then normally there's amendments that they actually do within those laws, or whether it's even to do with code of practice or any one of those. So they make those changes to ensure that they doing a continuous improvement and doing a more safe workplace. If we go back a little bit, we look at there's a lot. We've had a lot of probably safety alerts or incidents that have happened with quad bikes, with horse riding, also heavy transportation. We've had a lot of that with the logistics and that sort of stuff. So even in this new law, what they've done, they've focused on those. So there's been a lot of changes around that to ensure a safe workplace. Other changes in the laws have just been quite minute. It's just been basically like, changing clauses or wording in certain parts of the previous law of 2011. But something also for us as small, medium-sized business to be aware of is that they have, WorkCover has identified that small to medium-sized businesses seem to be non-compliant. So they're asking, so Safe Work is asking the inspectorate to do a lot more audits on small to medium-sized businesses. So that's really significant for us as small to medium-sized businesses to ensure that we are doing our due diligence and being compliant. thank you very much for listening. I look forward to hearing from you in terms of the questions you're asking or the comments you put there, so that that will help me to better improve on what I'm delivering, and probably also just look at other topics you might be interested in that I could deliver on video. So have a great day.